Welcome to Weber Gallagher University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. I am Chris Davis. I'm a partner in the Philadelphia office, and today I have the honor of presenting with Renee Prada Frazier, one of my partners who is in the Philadelphia and also the Pittsburgh office and covers Medicare. Each month we present a current topic in workers' compensation legal issues. We present both case updates and ways to manage risk in your business. If you would like to view this webinar again, share it with others, or see our other Weber Gallagher University programs, please visit our website, which is wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions about the seminar at questions@wglaw.com. Today's presentation is Considering Medicare's Interest, Conditional Payments, and Set-Asides. Next month, our topic will be Temporary Total Disability, Defense to Pay Obligation to Pay. So with that, let's get started. Welcome, Renee.
Thank you, Chris. I'm very happy to be here today to speak about Medicare issues, including conditional payments and set-asides.
So just for the audience's sake, how long has the concept of Medicare, taking Medicare's interest into account, been around?
Well, it has been around for quite some time. It really became an issue in workers' compensation when we were able to settle out the medical portion of claims with the 96 amendments. Since that time, we've needed to consider Medicare's interest. Over those years, however, it's become much more prominent as one of the settlement issues facing us.
So if you're a claims adjuster and you either have a case that's not in litigation, or you've referred it to defense counsel and they're litigating a claim petition or some kind of employer-based petition like a termination petition or a suspension petition, and you're looking to wrap up or settle the case, is this where this comes into play?
My recommendation for our clients is to begin considering Medicare's interest as soon as you get the claim. A person's Medicare and Social Security disability status can change at any time. So when I'm handling a case in litigation, I routinely send out questionnaires to claiming counsel to inquire as to whether there has been any change in claimant's status with regard to Social Security disability or Medicare. Waiting until we are actually at the point of settling a case can sometimes result in delays in the settlement. So this is something I like to inquire about throughout the course of the claim, including at hearings and prior to mediation in case we need to take any action prior to coming to a final settlement number.
One of the questions I often get is I get questions from clients about Social Security disability, Social Security old age benefits, the supplemental income part of Social Security. Just real quickly, what are those programs and which ones are the ones that apply to our context?
Well, the Social Security retirement benefits are benefits that a person receives potentially at age 62, or they can delay their receipt of those benefits. Simply being eligible for Social Security retirement does not mean a person is eligible for Medicare. If a person is eligible for Social Security retirement, they will become Medicare eligible at age 65. If a person is eligible for Social Security disability benefits, a person will become eligible for Medicare based upon receipt of those disability benefits after they have received 24 months of benefits. A person receiving a Social Security supplemental income does not have a guaranteed entitlement to Medicare benefits.
It's interesting. Okay, so let's go to the first slide. So the first slide is entitled Conditional Payments, and I see the word conditional payments come up a lot, and I've also seen kind of different people saying different things about what constitutes conditional payments. Can you kind of let the audience know what your view of conditional payments are?
Yes, the issue of conditional payments really becomes in the forefront when you're dealing with a person who is already a Medicare beneficiary. Conditional payments are payments that have been made by Medicare on behalf of the beneficiary for treatment related to the work injury. Once Medicare is aware of the work injury, they will review their files, and if they have made payments related to the work injury, they will seek reimbursement for those payments. Typically, we encounter situations where we have large Medicare conditional payment liens when we've had a contested claim where the person was receiving medical treatment for a period of time where the workers' compensation carrier was not accepting liability either for the claim in its entirety or for a particular aspect of the claim, such that the person was using their Medicare benefits to pay for their treatment.
So this would be like a claim petition setting where a notice of compensation denial has been issued?
We commonly see those situations arising in that situation. We also see instances where a person may be treating with multiple physicians for the work injury, and if they were already treating with a particular physician for conditions other than the work injury, oftentimes those physicians will not update their records to reflect that this is now a work injury, and those bills may still be paid by Medicare because they are being submitted even if the claim is not in a denial status. Therefore, simply having a case that has always been accepted and benefits paid does not guarantee that something has not been paid by Medicare.
So when Medicare just pays it, I mean, is it simply stamping it on the thing, conditional payment? How do we know it's an actual conditional payment?
What will happen is if the person is Medicare eligible, the injury must be reported to Medicare, and there are various mechanisms by which the injury can be reported based upon the status of the claim and who's making the reports. Once Medicare has the report of the work injury, they will use the diagnosis code for the work injury to review their record of payment for that claimant and determine if they have made payments for any treatment related to that diagnosis code. If they find treatment made, they will then submit to the parties a conditional payment statement. We then have the opportunity to challenge any portion of that conditional payment.
How do we challenge a conditional?
Typically, what you would need to do would be to supply to Medicare medical documentation showing that the payment was not related to the work injury. We've also had other instances in which we have challenged conditional payments on the basis that it was treatment that was actually already paid for by the workers' compensation carrier. If that's the basis for the challenge, you will want to present to Medicare documentation of the payment. Typically, we see situations where that has occurred where we may have had a dispute as to particular treatment or a particular body part, and then subsequently during the course of the litigation received a decision on that issue and payment was subsequently issued to the providers who, for various reasons, may not have issued payment back to Medicare for something they were already paid for. It could simply be a situation of timeliness, or it could be a situation where there was just a clerical error whereby they did not realize that payment was for the same treatment.
Let's go to the next slide. So the next slide is entitled Benefits Coordination and Recovery Center. What are the highlights of that slide?
Yes, the Benefits Coordination and Recovery Center is the center that you would call to make a report of the work injury outside of the Section 111 reporting. The Section 111 reporting is the reporting of the work injury made through the responsible reporting entity. Typically, this is the reporting that has been made when there has been a acceptance of the claim and acceptance of an obligation for payment of ongoing medical treatment. If it's a disputed claim, typically we will have either counsel or the claimant making a report to Medicare to ensure that they're aware of the existence of the work injury. Even with the Section 111 reporting, you can still contact the Benefits Coordination and Recovery Center to make sure that Medicare does have the claim on file to ensure that they have begun the conditional payment investigation. If they do have it on file, they can provide you with confirmation as to its status and whether it has been assigned at that point for the conditional payment investigation. Typically, it will be assigned to the Commercial Repayment Center, and the Commercial Repayment Center will issue correspondence to the parties with regard to the amount of conditional payment for which Medicare is seeking recovery. Once you receive that statement, that's when you can review it to determine if treatment was or was not related or whether there has already been payment. And in the letter sent by the Commercial Repayment Center, they will spell out exactly how you can submit any challenges that you may have to any portion of the conditional payment.
So the procedure of reporting the injury, I know in Pennsylvania now we're required to do like the first report of injury, and that's a form that we do the EDI with the Bureau, or the supplemental, the SHROI, it's a supplemental first report of injury. Is this a formal report, or is it an informal report, or how does it actually play out?
Okay, well, this is reporting to Medicare. And with regard to the reports to Medicare, not every case is going to be one that needs to be reported to Medicare. It will depend upon whether there is a settlement. If a case is being settled, that's something that needs to be reported to Medicare. If it's a case where you have ongoing responsibility for medical, such as an accepted case, that is something that needs to be reported to Medicare. Medicare has various portals and documentation for responsible reporting entities in order to make the report to Medicare. What we're talking about, though, here today in terms of the Benefits Coordination Recovery Center would be a different type of report to Medicare outside of the Section 111 reporting, whereby we could just make sure that they have the conditional payment investigation underway, and we can check on the status of that.
Is that typically done by phone, email?
You can call the Benefits Coordination Recovery Center and make the report of injury via telephone. I typically like to do it that way. That way I can make sure that they have the information correct. I recently had a situation where we were not getting any communications regarding the work injury from Medicare, but we were aware the claiming counsel had reported the work injury. So I contacted the Benefits Coordination Recovery Center, and I was able to determine through my discussion with them that while they had taken the report of injury, they had actually, in inputting the information in the system, they had an error in the input of the system. So by speaking with them, I was able to determine what the error was. They were able to confirm who had made the report. And by knowing who made the report and knowing what the error was, we were able to follow up with claimant counsel's office, have them contact the Medicare Benefits Coordination Recovery Center and correct the error so that they were able to move forward with the conditional payment investigation.
So let's move on to the next slide. The next slide is Medicare Advantage Plan. And if I'm an adjuster or an employer watching this, I might not be familiar with that term or that plan. Can you kind of give us an idea of what that's about?
Yes, the Medicare Advantage Plan, that would be part of Medicare Part C. Those are plans approved by Medicare for purchase by their beneficiaries. However, they are not actually administered or paid through Medicare. This is a private health insurance plan that you have for Medicare beneficiaries. One of the complications involving Medicare Advantage plans is when we request conditional payment information from Medicare, since these are not actually paid by Medicare but are private health insurance plans, Medicare will not have information regarding what they may have paid. Therefore, you still need to follow up with the Medicare Advantage plan to determine if the Medicare Advantage plan has made any payments for the work injury. This is not something that will show up in the conditional payment investigation. We do not see a lot of Medicare Advantage plans in workers' compensation claims. However, I do find that we see quite a few of them if we are dealing with an individual who was already receiving Social Security retirement and Medicare benefits prior to the work injury. That seems to be more common. Once we know the Medicare Advantage plan, we can request lien information directly from the plan and make arrangement for payment to the plan.
So this is a phrase that I am familiar with. I think a lot of adjusters are familiar with it. It's the phrase set aside. And I know some people have a misconception of what a set aside is and how it operates. So can you go through practically, what is a set aside and when does it not kick in?
Yes, a set aside in its most basic sense just means an allocation of funds from the settlement to pay for future medical treatment. What I encounter quite a bit is people wanting to have a more defined and limited explanation for set aside. And unfortunately, oftentimes that can lead to some confusion and apparent disputes in a particular matter when in fact the individuals are actually saying the same thing. They may just be using different terminology. So a set-aside in its most basic definition is simply an allocation of funds to pay for medical treatment in the future that otherwise would be paid by Medicare if it was not work-related. One of the interesting things about a set-aside, unlike conditional payments, is the obligation to set aside a portion of settlement does not require that the person be a Medicare beneficiary. The parties must always consider future medical costs when settling a workers' compensation claim and the potential impacts of Medicare. So in a set-aside, you can have a set-aside, whether approved or not approved by Medicare, for a workers' compensation claimant who is not a Medicare beneficiary. However, on the conditional payment side, which we have just discussed, that obligation and information does not come into effect until a person is a Medicare beneficiary, because a person would not be submitting bills and receiving Medicare payment for those bills unless they are a beneficiary. There is no such limitation on the need to set aside funds for future medical treatment.
So when we see a compromising release and we see language in a compromising release where the claimant is not a Medicare beneficiary, but the parties agree in the CNR form that $5,000 are going to be set aside. Is that okay? Is that not okay? Is that good practice?
Well, it's good practice to always consider Medicare's interest, and if it's anticipated that the person will require additional treatment for the work injury in the future, it is considered a best practice to set aside a portion of the settlement for that future treatment. Exactly how much needs to be set aside will be very fact specific, and there really is no set percentage or clear dollar amount that Medicare requires to be set aside in particular cases. It is very fact-based, and it will be dependent upon what the person's anticipated future medical treatment is. But it's always best, if the person is anticipated to have future medical treatment, to allocate a portion of the settlement and set it aside for that treatment.
And when we do that in a non-Medicare beneficiary situation, and we do that CNR, and let's say we take the $5,000 and we put that language in there, does that go directly to the claimant, or does that go to a different account that the claimant has access to?
That's a very good question. That's something that more and more claimants are beginning to ask because they're becoming a bit confused by it. The money does go to the claimant. However, it is recommended, and Medicare's preference is for the amount to be set aside into an interest-bearing account for funds only to be paid for medical treatment for the work injury that otherwise would have been paid if it were not a work-related injury by Medicare. Now, obviously, if a person has an existing account they want to add the money to, that's not considered a best practice. However, we as defense counsel and as claims adjusters do not have control over that. We do not set up the account for claimant. Claimant is responsible for setting up that account unless it would be a professionally administered account.
And this would be applicable in a situation where the claimant is not a Medicare beneficiary.
Yes, the same rules would apply if the person is or is not a Medicare beneficiary. The money really should be set aside into a separate account, but again, it is the claimant's money. They would have control over it. If they do have medical expenses, it's considered best practices as well for them to maintain the records for those bills, even if they are not on Medicare, so that if they do exhaust the amounts of the set-aside, they will have documentation to present to Medicare if and when they become a Medicare beneficiary.
So let's move on now. So the person's now, you're dealing with a settlement of a claimant who is a Medicare beneficiary, and Medicare is going to be involved, the agency that is Medicare. How does that work?
Okay, well, what Medicare has done is they have determined that it is really not feasible for them to review set-asides in each and every case. So they have set up criteria for when they will review a Medicare set-aside. Now, if the person is a Medicare beneficiary, Medicare will review a set-aside if the total settlement exceeds $25,000. However, even if the person is not a Medicare beneficiary, if they have a reasonable expectation of Medicare eligibility within 30 months of the settlement, Medicare will still review it if the total settlement amount exceeds $250,000. If you are submitting the set-aside to Medicare, Medicare has a series of protocols and criteria for the submission of the set-aside for them to approve it. Again, this is not a safe harbor whereby you don't have to consider Medicare's interest if the review threshold is met. It just tells us when Medicare will actually review a set-aside and give you a determination.
So one of the things is the phrase reasonable expectation. Can you kind of elaborate a little bit and explain what is a reasonable expectation in the context of Medicare?
Certainly. A person has a reasonable expectation of becoming a Medicare beneficiary based upon age. If they are age 62 and a half, it is reasonable to expect that they will become Medicare eligible at the standard Medicare age of 65, so they are within the 30 months. Also, if a person has applied for Social Security disability under Medicare, they do have a reasonable expectation because a person becomes Medicare eligible automatically after receiving Social Security disability benefits for 2 years. Therefore, if the person has applied for Social Security disability and has received benefits, they have a reasonable expectation. However, even if a determination has not yet been received by Medicare, there is still the reasonable expectation that they could receive benefits to a point prior to when you are having the settlement, such that they are within 30 months. This would apply if you have no decision on the Social Security disability application, if you have an unfavorable decision but the person has appealed, or even if the person has not yet appealed but is still within the appeal period, they do have a reasonable expectation of having Medicare eligibility within 30 months because they could still receive Social Security disability benefits based upon that outstanding application. Additionally, individuals who suffer from end-stage renal disease will become eligible for Medicare benefits. That is not something we see very often in the workers' compensation context. Traditionally, we see more the individuals involved with the Social Security disability application.
Now, one of the other issues that comes up is the dollar threshold issue, and the $25,000 or the $250,000. What goes into determining what constitutes that $25,000 or $250,000 number?
That's a very good question. And basically, anything that you are paying in terms of the settlement is included in that dollar threshold amount. That includes indemnity, medical, specific loss, attorney's fees, payments to other individuals, whether they are reimbursement of medical expenses or reimbursement of a indemnity plan that the claimant may have received through a third party. If those amounts are being paid as part of the settlement, that needs to be included in the total settlement amount. Additionally, we have situations where we may have had one portion of the case settle at a prior date, such as an indemnity-only settlement, and now we're settling out the medical. If there was a prior settlement, you would need to include the amount of that prior settlement.
So if the case settled for $75,000 indemnity 5 years ago, that you'd have to figure that in.
Yes, you do.
What about, so let's say I'm litigating a claim petition and it's been pretty extensive, and there's been litigation costs incurred by the claimant's attorney of maybe he took 2 doctors' depositions and they come in at about $9,000. Do litigation expenses, since we're going to reimburse them to claimant's attorney as part of the CNR, does that get included in that number?
Under Medicare's broad interpretation of what is included in the dollar thresholds, that would be something that would be included because it is an amount being paid as part of the settlement.
It's interesting.
Another thing to consider is oftentimes we have cases where a portion of the settlement may be funded via an annuity structured settlement, and in determining whether the dollar threshold has been met, Medicare looks at the total amount of the payout over the expected life of the annuity, not the cost of the annuity. So you may have a situation where The cost of the annuity is only $24,000. However, the total payout is expected to be in excess of $25,000, so you would look at the total expected payout to determine if the review threshold dollar amount has been met.
And what are the situations where no set-aside would be required?
That's also a very good question because we do encounter those in some instances. A situation where you would not need a set-aside would be one in which the medical is simply not being settled. Although it's less common now than it was in the past, we do still have cases in which only the indemnity or specific loss is being settled. In those cases, because medical is remaining open and the obligation of the defendant, you would not need a set-aside. Another situation would be one in which it is not anticipated that the claimant will need any additional treatment for the work injury. If you are going to present a $0 set-aside either to Medicare or simply as part of the settlement on that basis, you will want to make sure that you have sufficient medical documentation from a treating physician to support that position. We've also had success in obtaining $0 set-asides in disputed cases where there have been no payment of benefits and the occurrence and compensability of the work injury remains at issue even in the settlement.
So Renee, we're coming to the end of the webinar today, and hopefully the audience will have found it as exciting as last night's presidential debate.
Let's hope not.
But can you give us kind of a summary of kind of where we are with these set-asides from a timeliness perspective and a ease of dealing with the federal government at this point?
I think that's a setup question. But what we are seeing is some improvement in the turnaround time for Medicare set-asides. The biggest thing we have to focus on is when we are submitting the set-asides, we need to make sure that we have all of the medical documentation, including payment logs and prescription logs, because Medicare does want to see those, and if we do not have something, Medicare will request a supplement, and that will delay the final determination. So it's very important to make sure that we have all of the information, and in order to do that, we need to make sure that we keep an open dialogue between all parties, as sometimes claimant and counsel may be aware of something that we on the defense side simply don't know about that could impact upon the Medicare set-aside.
And if people want to, if the adjusters or the employers want to get a hold of you down the road, what is your either your direct dial or your information to reach you easily?
Certainly. My direct dial is area code 412-281-4573, and my email is rparada@wglaw.com.
Well, thank you, Renee.
Thank you, Chris.
Sure. Thank you for attending our webinar considering Medicare's interest, conditional payments, and set-asides. Our next program will be on October 18th from our New Jersey office, entitled Temporary Total Disability, Defense to the Obligation to Pay. Our attorneys will review the defenses to the demand for temp and when it can be properly refused even if the petitioner, who is the employer, is not employed, and may even need treatment. Employees are entitled to temporary disability as long as they are actively treating in New Jersey and unable to work from a work injury. You can learn more about this program and all their Weber Gallagher events at www.wglaw.com/WG-University. With that, thanks and have a great day.